It's now 12:01. I'll get started. Thank you for coming to the webinar. It's Keeping Bylaws Current. If you don't know me, I'm Zachary Currie. I'm an associate lawyer with Dominion GovLaw. I'll be presenting this webinar. It was prepared by Kevin Creery, who's a bylaw officer. And let's get started. Sorry. So on the agenda, we have number 1, why legal reviews matter. Number 2, how to build a 3 to 5 year review cycle. Number 3, recognizing red flags and outdated bylaws. And 4, tools staff can use immediately to address and revise their bylaws. So why do legal reviews matter? Well, the first reason is for legal compliance. As you may know, local governments are creatures of statute, and everything that they do must be in conformity with the provincial legislative framework for local governments, whether that's the Community Charter, the Local Government Act, or something like the Agricultural Land Commission Act. So it's very important that local governments are ensuring that their bylaws are legal, because if they're not, they'll be unenforceable. And this is something that changes over time, and that's probably the most important aspect of doing bylaw review is ensuring that your bylaws are in compliance with the ever-changing provincial legislative framework. The second reason is risk management. And so this has 2 aspects. The first aspect is that some bylaws are inherently about public safety issues and deal with risk to the public. So a good example of that is the building bylaw. And it's very important that a bylaw is kept up to date and is enforceable in order to prevent certain risks to public safety. Another good example of that is animal control bylaw. You want to make sure that your bylaw is taking care of any risks associated with dangerous animals, dangerous dogs, in the jurisdiction to avoid injury to the public. The second aspect of this is that there's risk for a local government when they enforce their bylaws. So if a bylaw is being enforced in an inconsistent manner, you might end up with a lawsuit. So the way that this could take place is, for example, suppose a bylaw on its face doesn't allow a secondary dwelling, but out of policy, a bylaw officer decides to allow somebody to have that secondary dwelling. Well, later on down the road, the city decides, well, this was always against the bylaw, it should never have been allowed. That person's already built the secondary dwelling, incurred the expenses. Even though it is still illegal, it's not allowed by the bylaw. If you ask them to demolish it to bring their property into conformance with the bylaw, they might have a suit against the local government for doing that because they relied on the representations of one of the officers and incurring those costs to build the secondary dwelling. So that's really important to know. And this will come up later. And actually, it's the third point is consistent enforcement. Bad bylaws are not going to be enforced consistently, and they're going to leave open, with staff turnover and everything, all kinds of room for interpretation, as different bylaw officers will act with the public differently at different times. So that brings us to the next point, is consistent enforcement. Even liability aside, it's just a principle of good governance that you're consistently enforcing your bylaws. And the more deficient a bylaw is, the more problems it has, the less consistency you have in enforcement. And the reason for that is because if there's a gap in your bylaw, it doesn't address something it should, or there's ambiguity caused through bad drafting, bylaw officers are going to be enforced to interpret it. And it's very possible that they might interpret it in different ways if it's not clear how the bylaw is to be enforced. And this can ultimately result in the public feeling that they're being treated unfairly, because how the bylaw is enforced depends on who you talk to. The fourth reason for legal review is that you constantly need to align the bylaws with council priorities. So council might decide they want to increase density, to increase affordable housing. It's important to review your bylaws to make sure your zoning is not restricting the building of and construction of dwellings unnecessarily. Bylaws, it's not uncommon for us to work with a bylaw, especially in smaller jurisdictions, that comes from 30 years ago. And that clearly is not, that bylaw is not reflecting the current reality of that jurisdiction, which will have grown in population and economic development by quite a lot. And so it's very important as local governments grow and change that the bylaws are still reflecting the realities of the jurisdiction and satisfying the public as to their usefulness and viability. The last point here is public trust, and I've already mentioned this is kind of actually part of all of the four previous points, but if you've got bad bylaws, people aren't going to respect them. And if the people don't respect your bylaws, you're going to have compliance problems. You're going to have complaints. So it's really critical that you have a bylaw that's readable, easy to understand for the public, so that they are on notice for what they're supposed to comply with. And most people, as you know, they do comply with the bylaws, of course. But the percentage of the complying population will decrease proportionately with a lack of respect for the bylaw, which could come down to, like I said, legislative gaps and poor drafting and not meeting the current realities and objectives of the elected mandate. First, we'll consider now the BC legislative context. Like I said, local governments are creatures of statute. They need to do things, enact things both procedurally and substantially in conformity with the provincial legislative framework. Revising bylaws can be done in different ways. If it's a substantive change of the actual law, you're going to need to do an amendment. If you just want to put a bunch of amending bylaws together into one, you're going to do a consolidation. And if you want to do some housekeeping, just clean up drafting errors, make clear something in a bylaw that's either latent or ambiguous, then you can use a revision bylaw. And there's different mechanisms for each one, and you have to follow different procedures for each type of bylaw you're enacting. And that all comes from sections 137, 139, 140 of the Community Charter. Also the bylaw revision regulation, which sets out all the different ways in which a revision bylaw can be enacted and for what purposes. All these sections apply to the regional district pursuant to Section 227 of the Local Government Act. So when you're revising a bylaw or amending it, probably in the example where you're actually going to change the law to make something either permitted or prohibited that wasn't previously permitted or prohibited, you're going to be subject to the possibility of your bylaw being judicially reviewed. And so in a judicial review, the court is going to scrutinize as to whether the bylaw is in fact within its lawful authority, that it fits within that legislative context that I talked about. And the things they're going to look at is first whether it's authorized. The provision that you add to your bylaw, is it actually within the realm of categories that the bylaw is allowed to regulate? So this comes from mostly from Section 8 of the Community Charter, and then other sections of the Local Government Act and zonings from the Local Government Act. So the question is, what you're legislating, does it fall within the ambit of the Community Charter of the local government? If it's not, then your bylaw is going to be vulnerable to what's called an ultra vires challenge. The second aspect is whether the bylaw is reasonable. So even if you enact a major change to your animal control bylaw, that clearly comes from the legislated powers under the Community Charter. There's going to be a question of whether that bylaw itself is actually reasonable or not. And the law for that is pretty well settled and comes from Catalyst Paper Corp versus North Cowichan District. That's a Supreme Court of Canada case in which the Catalyst Paper Corporation was basically upset with the level of taxation they were getting from North Cowichan, and essentially brought an action to find that the tax bylaw that provided for that bracket of taxation was unreasonable. And the Supreme Court of Canada ultimately ruled against them. And the reason for that is that there's actually very narrow grounds on which to overturn a bylaw for lack of reasonableness. The test is pretty strict. The courts want to give local governments a lot of room to consider all kinds of factors, all kinds of aspects of the electorate, all kinds of policy reasons to carry out their mandate. And so reasonableness is always going to depend on the bylaw and the context of the bylaw. But essentially, it's a matter of whether the elected officials have recognized and made their decision according to a wide variety of factors that elected officials are allowed to consider. So obviously, factors that are should be considered are considerations that were made in bad faith that will be overturned. But otherwise, the test is really that only if the bylaw is one that no reasonable body informed by the factors could have taken will the bylaw be set aside. So you can see that's pretty strict, especially because local governments are allowed to disagree with each other all across the country on policy reasons. And it would have to be that nobody could possibly think that the policy reasons and factors considered were justification for the bylaw that was put in place. So I guess that's just to say that in most instances, you're going to be pretty safe when you're doing your bylaw revisions. Most local governments are acting in good faith, and they're revising a bylaw because they need to. And so usually that inherently means that they're considering the factors that they're supposed to as elected officials. So the next point is the 3 to 5 year review cycle. So all local governments should have mandatory and regular review cycles for their bylaws. Whether it's the length of time for each cycle or each period for review is going to depend on the nature of the bylaw. So I have here a high risk bylaw. You would review it every 3 to 5 years. A medium risk bylaw, you're going to review every 5 to 7 years. And a low risk bylaw will be trigger based. So basically review when necessary. And a high-risk bylaw would be something where public safety issues are implicated by the regulation. So a building bylaw is something that needs to be it needs to be made. You need to make sure that a building bylaw is up to date and it's enforceable, because if it's not and you have problems with people complying, it could result in safety issues for the public, for people buying homes, etc. A medium risk bylaw would be something like a noise or nuisance bylaw. So it doesn't necessarily bring in the health and public safety concerns of something like a building bylaw, but it does involve concerns with, let's say, interference with people's property, which is still important. This is something that that the public is going to care a lot about, and so non-compliance with those bylaws can have quite a significant impact on people's lives. The third category, low risk, would probably be something like a public parks bylaw. Private property isn't really implicated, and there isn't generally public safety issues. And so this doesn't have to be done regularly. It can just be done when necessary. And example of triggers would be legislative change. And by the way, with legislative change, even if you've only got your review on for 3 to 5 years, you're going to want to do it immediately. So, for example, recently when the Local Government Act was changed to require to provide for certain density requirements in zoning bylaws, that's something that local governments are going to have to get on right away. They're given a certain grace period to make their changes before the provisions totally come into force. So legislative change is definitely something that's just going to trigger bylaw amendments for whatever category of risk. But for low risk bylaws, that might be the only thing that really triggers the need for change. The second trigger would be council priorities. It's possible that at one time, let's say, commercial vehicle parking wasn't that much of an issue in the jurisdiction because the population was small and people just weren't parking big trucks. There wasn't the level of commerce or industry in which that was appropriate. 20 years later, or maybe 10 years later, suddenly people are parking these trucks everywhere because it's cheap for them to park on their own property. And then council has a priority to enforce its zoning and make sure that trucks aren't being parked in residential areas, trucks aren't being parked on agricultural properties. And in that case, you might need to amend your bylaw to tighten up the provisions on parking or zoning. And the last trigger is enforcement issues. So you might have a bylaw in the abstract, just reading it, it seems fine, and this is very common, but suddenly you go to enforce it, and it's only at the time of enforcement that you realize the problems with it. Maybe to realize the problems with getting the evidence you need to back up a certain provision that won't necessarily be recognized at the time the bylaw is enacted. It's only experience in dealing with the public. You realize that provision of the bylaw really becomes unenforceable. And if you lose something big like a long form information prosecution or injunction because the bylaw is ambiguous, that's going to be a lot of money wasted. And so that's going to trigger you to change the bylaw. But for these high risk bylaws, you're going to want to get ahead of that. And if you have the resources and time, then of course do it for all your bylaws. But again, the reality is that local governments are always juggling priorities, and you have to be organized and methodical about how you do this. And that's really the point of the 3 to 5 year review cycle, is to be methodical about how you address your bylaws and their deficiencies. Because if you don't do this in a way that's regular and mandatory, it's always going to be put off. There's always more current and more pressing priorities than reviewing a bylaw. And it's probably something that most people don't even want to do anyways. It's a lot of work. So unless you're mandating this and making it regular, it's just never going to happen. And then you're going to run into the problems with enforcement when it's too late, or worse, liability issues, or you end up being sued for damages based on deficient enforcement. So the next slide is making it manageable. This is about how do you do bylaw review in a way that is manageable and can be done efficiently and effectively. Like I said before, if you're not implementing those review cycles every few years, it's going to be overwhelming when you do go to try and clean up the bylaws. It will be difficult to choose where to start with your bylaws because you'll have all kinds of different bylaws that will have different priorities, and if you're doing it all at the same time, you're going to run into problems with lack of resources. One way to keep track of, let's say, things like triggers or which bylaws are a certain level of risk, and which bylaws are really not doing the job that they should be doing, is by keeping a bylaw inventory. And so a local government should have an inventory where it's easy to access all bylaws present and future and compare them. And you don't necessarily have to read the entirety of a bylaw to figure out what's going on. There should be summaries that people can read to know whether what a bylaw is about, and whether it needs to be addressed, whether it's a high risk, medium risk, or low risk bylaw. It should be easy to review changes over time, so you're not going back and reinventing the wheel, putting in a provision that didn't work 10 years ago. It's very easy for that kind of thing to happen. I'll talk about this in a minute, but essentially, institutional knowledge is something that has to be actively maintained. It's not necessarily easy to do, and staff turnover makes that very difficult. And all local governments are subject to staff turnover. So this is part of building that institutional knowledge, is by having a bylaw inventory with the right kind of information to make it easily searchable and useful. The second way of making bylaw review manageable is through department ownership. So bylaws will generally deal with certain issues belonging to certain departments. The most obvious one being that building department deals with building bylaws. And so to sort of implement the right division of labor, bylaws should be assigned to different departments so that it's their responsibility for taking care of that bylaw and keeping it updated. It's going to be hard if you just have one department, maybe just legal department, doing these reviews. It's always better to split label where you can and give it to the people who have the specialized knowledge of that area. Another way of dealing with bylaw review is housekeeping bylaws. And housekeeping bylaws are going to be the kind of bylaws that fall under what they're called on the community charter, like the revision bylaws, which are going to clean up for drafting errors. And this isn't any small task or an unimportant task, even though it's called just housekeeping, because it's the inherent ambiguities that come from poorly drafted bylaws that can result in serious enforcement issues. So it's really important that these bylaws are done to revise bylaws and ensure that they make sense, that the references are referencing current things and not obsolete things, etc. And with the revision bylaws, you can essentially revise all your bylaws at once with one revision bylaw. It's basically unlimited, the amount of bylaws you can do at the same time. So it's something that can be done regularly and wholesale. And because it's correcting for, let's say, minor errors like grammar and that kind of thing, it's not the same as undertaking a single bylaw revision that is going to substantially change the law in the jurisdiction. And finally, on making bylaws manageable, we have annual reporting. So this is really important for local governments to implement so that they are making informed data-based decisions. And this goes back to the problem with turnover and institutional knowledge, as that one bylaw officer might be very familiar with a bylaw, understands instinctively or intuitively the level of complaints that the local government receives with respect to that bylaw and those issues, or they understand how far you can get with certain provisions, whether they're stopping at voluntary compliance or they're finding they're going all the way to enforcement, how often that happens. But that knowledge needs to be shared with the rest of the local government. It's always going to be partial if it's just one bylaw officer and it's just what they keep in their head. If you want a complete picture of how your bylaws are doing, you're going to need to have reporting systems in place that gather data and put it in a place like the bylaw inventory that's easily accessible. And so if you've got one person that was going to work on a bylaw, they had the best knowledge of it, suddenly they leave, someone else can come in, step into their shoes, and look at that data and know where a bylaw needs to be addressed. Important things that annual reporting can do is you can determine whether complaints have increased or decreased with respect, which is a good indicator of whether proper enforcement is happening, or just not even whether proper enforcement is happening, but whether more enforcement needs to happen or less enforcement needs to happen. This is all part of managing your resources and only spending it where it needs to be spent in the most efficient way. Is compliance being achieved? Has the bylaw gone all the way to the final stages of enforcement? Has a court ruled on it and said and given you the okay on your tickets or on your long form information prosecution? If you you should have a data bank of all the cases you either won or lost with respect to a bylaw, so you know what needs to be changed and what doesn't need to be changed. And then I already mentioned this, but are resources being allocated efficiently when it comes to bylaws? If you've got a lot of complaints in one area, you need to direct your resources into that area. But you can't know this just through a patchwork of bylaw officers' different experience over time. You need to bring everyone's experience together and put it in a format that's manageable, and that can be accessed by anyone to get the best picture of what you need to do next with your bylaws. So, red flags in outdated bylaws, how bylaws become outdated. So one way is reactive amendments. And reactive amendments aren't necessarily bad in and of themselves. I mean, most of the time they're actually necessary. You have a specific problem, your bylaw somehow doesn't address it, you lose a case on it, or you feel like you can't go forward. And so you amend that one part of your bylaw that deals with that issue. The problem is if you're only amending your bylaw faced with reactive amendments, over time, you end up getting a patchwork bylaw rather than a consistent and coherent bylaw. And you end up creating more enforcement problems than you originally had because you have a bylaw that's open to all kinds of interpretation because there's all kinds of inconsistencies throughout it, or at least implied inconsistencies with the way that it's been kind of put together like a Frankenstein's monster rather than put together in a coherent fashion. Is also the possibility that when you make a reactive amendment for a specific issue that has arisen, the public is either an event happens, somebody gets bit by a dog, or etc., or the public just has certain goals that it wants to meet at a certain time, certain needs, and you react just to that moment. Not that you shouldn't do that, but it could be that 10 years down the line, those concerns are no longer a problem anymore. And that your bylaw is either maybe like too strict or too onerous in a way that was meant to reflect the needs of a certain time and the needs of a certain event or the desires of a certain public, and that's now just obsolete. And you need to get rid of that reactive amendment because it's not now fulfilling public policy the way it should. Another way that bylaws become outdated, and this should be obvious from what I said before, is no scheduled reviews. Like I said, if you don't have scheduled reviews, people are just going to put it off forever. Nobody's going to do it unless it's scheduled and mandatory. Local governments are busy, and you're going to either forget about it or you're going to put it off. So it's really critical you have a policy for scheduled reviews in place that people are following regularly and adhere to. Next way a bylaw becomes outdated is staff turnover. As I said before, there's a problem with maintaining institutional knowledge when you have staff turnover. Staff might have a policy that they've developed for dealing with enforcing a bylaw. When new staff comes in, they don't know anything about that. And then you have that policy basically goes to the wayside, even though if it was a good policy, because nobody knows about it when they're enforcing it. If you find that a bylaw that you're using your discretion to enforce it in a certain way, let's say for zoning, you say in agricultural properties we're going to allow 2 commercial vehicles, but no more than that. After that, it becomes a truck yard or something like that. That should just be eventually, if that's the policy that everyone's following at a time, it should just be built into the bylaw. Those 2 vehicles that 2 vehicle exception needs to make its way in. Otherwise, other people are going to come and they're not going to agree. Maybe they just don't agree with the 2 vehicle exception, or they just don't know about it. And then you're going to get this inconsistent enforcement. And something that would worked in the past has now basically been abandoned just because there wasn't a regular review that was consolidating and making explicit what was implicit in the bylaw. And lastly is informal workarounds. This is related to what I just said. So bylaw officers will know if something is unenforceable, so they might have an informal workaround where they say, well, we'll just try to get involuntary compliance. If we can't get that, we won't go any further, and we'll just leave it at that. That's something you don't want to last forever. It makes sense at a certain point in time, but especially if people in the public starts catching on to that, saying, oh, look, they never even enforced these anyways, right? So you go ahead, break them. It doesn't matter. Those kind of informal workarounds of the deficiencies of a bylaw eventually need to be amended and accounted for in a regular review. So what are some examples of this? Well, you could have zoning bylaws that are missing modern housing forms, and this is reflective of recent changes in the Local Government Act, where they increased the density requirements. They made it so that most zones have to allow for a secondary dwelling or a carriage house or a laneway house. These alternate forms of dwellings and housings are something that might be totally missing from a bylaw. And if you don't know about that, if it's not built into your bylaw, you'll go to enforce against someone, spend a lot of money and resources on investigation, and eventually end up losing your case because your bylaw is essentially illegal. So you need to make sure that you're keeping your bylaws current in accordance with provincial legislation and any other enactments that might apply. The next one is a big one, fee bylaws not reflecting real costs. If you've made a bylaw in the 80s, there was a certain amount of costs associated with running the population size that existed in the 80s. There's a certain level of inflation that existed at that time that doesn't exist now. And so the fees at that time won't reflect the way the fees should be now to actually support the real cost of administering the bylaw. So this is really something that's very easy to become outdated. It can become outdated quite fast and needs to be changed regularly. And fees aside, I found myself from working in local government work. For example, it was I can't remember the exact year, but at some point the Community Charter and Local Government Act changed so that you could get up to $50,000 in on a long form information prosecution per conviction. And yet we'd still find bylaws that had like a $2,000 maximum, right? From a long time ago, and you just can't do that much. And it's well known now that that bylaws are becoming more difficult to enforce. The property owners or the people contravening the bylaws are becoming more sophisticated, and there's a bit of an arms race between the local governments and people contravening the bylaws. And if you don't have the fines to enforce your bylaws to recover costs, for example, you're not gonna end up enforcing them, or you're going to enforce them at a high cost to yourself. I find that I've seen bylaws where the minimums are either non-existent or really low, at $200 or something like that, which is more reflective of a ticket rather than a prosecution. And that's really important to change, because when you go into court, and many people, because prosecutions don't happen that often, you prosecute someone, it's their first time, the court is going to look at that base minimum to make their decision. And if it's the first offense, it's going to be quite low because your minimum is low. If your minimum was at $3,000, the court can't go below that. They're going to do $3,000. So it makes a huge difference when you have these minimums, because they directly impact the way a judge is going to sentence on any given case. And the lower your minimum is, the lower your fine is going to be. You might go in and argue, oh no, I think this should be $5,000 even on the first count, because that reflects current sentencing decisions or something like that. And that's a consideration, but it's also a consideration that your bylaw has the fine set at a minimum of $200, and that's not going to get you the $5,000 that you want, especially not on a first-time prosecution. The next example is a bylaw that does not reflect policy decisions. So again, like I said, over time, councils change. That's obvious. That goes without saying. But especially over long periods of time, the range of policy options that any given council is going to consider is going to change. And if your bylaws are from the 1980s, and we're operating now in 2026, the range of policy decisions that council wants to make and wants to promote in the community is not going to be consonant with bylaws that are from decades ago. So it's really important that that bylaws are kept up to reflect the ongoing realities of local governments and the elected mandate. Last example that's very common is obsolete bylaw references. And this, like I said, comes from reactive amendments or just not updating over time. But I'll find that reactive amendment might take out a reference to something, and then that reference is still in another part of the bylaw. References maybe a position in the local government, let's say deputy city manager, that doesn't exist anymore. That bylaw provision essentially becomes useless because it's not reflective of the reality of how the local government currently operates. You also might have references to obsolete acts. Again, it becomes unenforceable because the thing that is being referenced no longer exists. There's a caveat to that, in that you might have a bylaw that says references Section 3 of the Motor Vehicle Act, and then the Motor Vehicle Act changes and it becomes Section 5. As long as the substance has stayed the same, there's rules under the Interpretation Act, etc., that make the reference to Section 3 a reference to Section 5. But if legislation changes entirely, if the nature of the law changes, those references are no longer going to be are going to be working because you can't just automatically reference a totally new law based on an old reference, that reference to previous act. So what are the consequences of not updating bylaws? Well, under legal and governance, we have ticket dismissals. This is the most obvious one. Your bylaw's out of date. It's deficient. It's not reflecting the realities of current enforcement, or it just never was enforceable in the first place, and you never find out until the first time you get a ticket. You're going to find that you're not getting the results you want, despite all your time and energy spent in investigation. Another one is judicial review risk. You have the possibility of a decision in local government being judicially reviewed and being found unreasonable because the bylaw doesn't support what the local government wants to achieve. So your permitting requirements, for example, need to reflect exactly what the council wants to do with that bylaw, or else on judicial review, it's going to what you wanted to do with a permit or do with a denial of a permit is going to look unreasonable in light of what your bylaw actually mandates. And this goes to the third point, that council direction will be undermined. Current policies won't reflect what council currently wants to do with their bylaws, and including permitting requirements. Public trust is going to be eroded from deficient bylaws. I mentioned this at the beginning. You never want it to be where where residents are starting to say, well, what the bylaw means, how it's enforced, depends on which bylaw officer you talk to. So hopefully you get a nice one that's going to see things your way. People want to be painted with the same brush. They want to be treated fairly, and deficient bylaws don't treat people fairly, and they treat people differently according to the facts and circumstances of the case. You'll get more complaints and appeals. So you'll get complaints, I guess, in multiple ways. Complaints of bylaw infractions will increase because you're not enforcing a bylaw that's inherently unenforceable, or you'll just get complaints, like I said, about people who find the process is unfair because the process was directed towards concerns that happened, a decade ago and aren't relevant anymore. And you'll get appeals, so that if there is a decision, you're successful on a prosecution, you're successful on an injunction, people are going to be more inclined to appeal it when they really feel that they didn't receive the just outcome. And that's more likely to happen if the bylaw is deficient. And you could, for example, read all kinds of things into it. It might be that a judge saw things your way. Usually your interpretation is reasonable, but so the other person's interpretation, so long as the bylaw is not clear and is ambiguous and could be read in different ways. And then this is all just to say that there's a reputational risk for local government when they're not governing in a way that is transparent and fair. And deficient bylaws are not going to be transparent. They're going to lack that. And the actions of a local government are going to be are not going to be reasonable or scrutable to the public in a way that the public feels that that they're being treated in a fair manner. So like I said before, it's important that reviews are linked to council priorities. You need to be using your laws and enacting laws in a way that reflects the current elected mandate. So for example, with housing, you could have a problem where you have restrictive, and I mentioned this before, restrictive zoning requirements that are not supporting the current need for affordable housing. And so you need to be updating your zoning bylaws or anything else, maybe even your building bylaw, to reflect the current need for building more homes and increasing development. Environmental concerns, it could be that maybe in the 1980s, when the population was very small, you never really had people disturbing the soil. You now all of a sudden, fast forward to 2026, you're a much bigger local government, and you've got all kinds of people that want to make changes to their property, that have the money to do so, and are causing bank erosion, and it's affecting the water quality or something like that, you might find that your permitting requirements are too lenient now, and people are getting permits, and it's not doing what they're supposed to do because you're not accounting for all the factors you need to, where there's high level development going on. So you need to tighten up your permitting requirements for your soil deposit bylaw. And the last one is economic development. Maybe council wants to improve economic development, and the way they can do that is by adjusting their bylaw, deregulating in a way that helps make it easier for businesses to operate. Example of that is easing restrictions in your business licensing bylaw. Though it might have been appropriate at one time, those restrictions are no longer necessary or appropriate. A lot of business licensing bylaws are going to interact with provincial acts, let's say provincial acts to deal with health. So if a health authority begins to regulate something in a way that your bylaw used to do because there was a gap in the legislation, then you might want to take out the mandatory requirements in your bylaw, dealing with the aspects that the health authority now regulates, essentially easing the burden on businesses so that they're not double regulated in any way, and that's going to help you increase economic development. But you're only going to see that if you're reviewing your bylaws and looking at the sort of web of interconnected legislation that is currently in place. So what can you do immediately to help improve your process in local government for regulating bylaws? Well, as soon as enforcement of something feels uncertain, that needs to be flagged, and you need to sit down and reflect on why the bylaw is not achieving what it needs to do, and how you can go about changing it to make sure that enforcement feels certain and it's achieving the effect it's supposed to. Workarounds are used. This, like I said before, if you've got a workaround where you just don't enforce one provision of the bylaw, or you've got two overlapping provisions in your zoning bylaw and you only enforce one of them, the one that's actually more vague because the one that is more precise is a mess, and it can't be enforced. You want to sit down and figure out again how you're going to go through your bylaw and change that so that you're no longer using this workaround, and especially a workaround that's going to change with policy and staff turnover. Another one, fees don't reflect costs. This is pretty easy to see. If you review your bylaw and you see that you're only getting $50 per ticket, and you see that enforcing your bylaw department is now costing X amount of dollars to enforce, you might want to take a second to sit down and reflect how you can increase fees that reflect people's the current income of people in the jurisdiction, and helps to support the costs of running a bylaw department. And lastly, if your policy and bylaw conflict, like I said before, if you've got a policy that says you can have two commercial vehicles on a given property and your bylaw doesn't allow any, but you want to be more lenient for people, then sit down and work out that conflict and change your bylaw. And we can, of course, at Dominion GovLaw help you with any of these needs at any time. We're always open for a consult on it or actually doing the drafting ourselves. So key takeaways: currency is a governance issue. As I said, public trust depends on transparent and fair bylaws. If your bylaws aren't current, they're not going to be seen as fair or relevant or transparent, as the policies that enacted them don't reflect the policies now, and you're going to suffer a reduction in public trust. Regular reviews reduce risk. Like I said, reviews aren't going to happen unless they're regular. And with regular reviews, you're going to be able to catch deficiencies in the bylaw that could potentially result in liability for the government or public health safety issues for the residents. The next one is that simple systems work. This is something that can be difficult to practice, as with a bylaw, you might want to overcomplicate things to make sure that you're regulating everything you want to, but sometimes overly complicated bylaws can themselves be a source of unenforceability later down the line. In terms of just your review process, you want to make sure that review process is simple, it's streamlined, it follows standardized workflows, and don't overcomplicate those bylaw reviews, or you're going to end up with, again, a system that is just not manageable. And finally, staff input matters. Bylaw officers are going to be the people that have the most knowledge with enforcing a bylaw, with what it takes to enforce a bylaw, with the evidence that needs to be gathered. Bylaw review can't just be done by the higher management level or council without input from the people that know what it takes to actually enforce that bylaw. And so I will end with that and open up the webinar for Q&A.
So there's something. Dale Clinton's asking, how do you balance updating bylaws to be more enforceable without making them overly rigid?
Yeah, this is a good question. I think, like I said, keeping matters simple is definitely something that is more difficult. It's easier said than done. But what you want to do is think about the issue that you need to address, and try to address that in the most simple way possible and language in your bylaw that's clear to the average person. You're usually going to come up with a good answer. If your answer is for how you address an issue is maybe too clever or too Byzantine, it's not going to make sense to the public, and it's going to be a bad bylaw. So it all comes down to clear and plain language. Make sure that you're able to encapsulate an issue in a way that's simple and clear, rather than try to regulate all aspects of it. Because what the reality is when it comes down to it, you will be able to regulate an aspect in a way with general categories that you might not be able to do with more specified categories. But like I said, there's always a balance there, right? Sometimes you need specification, you need specificity to get where you need to go. But it's just a matter of practice and experience, and especially institutional knowledge. You need to know what has worked in the past, what level of generality has worked in the past, and then try to apply that to the current problem.
We have another one here. Do you recommend any bylaw revision procedures upon each new council term?
Bylaw and provision procedures sorry, can you say that again?
Yep. Do you recommend any bylaw revision procedures upon each new council term?
Oh, okay. I don't think so. I don't think that's necessarily the case, that you'll need to do a bylaw every time there's a new council in place. I think that if you stick to more of like the yearly reviews, you'll be in a better situation. I know that council policies change, but I think that most of the time, if in 5 years, your bylaw needs to change and you've got it regulated for that 5-year period, you're going to be current with any kind of current council policy. I wouldn't worry too much about following the kind of the ins and outs of council. Stick to your own schedule, and you should be okay.
You mentioned that bylaw revisions could be done by Dominion GovLaw. I understand the affiliation between the regulators and Dominion GovLaw. Just wondering if that was a slip or if it's either or both, or.
Sorry, yeah, it's either or both. Actually, I think it's primarily done through the regulators. But if you've just got like a single question about your bylaw that you want us to canvass before it goes to something like the regulators, it might be best for a lawyer in Dominion GovLaw to look at it. But yes, they should be primarily done through the regulators.
Where do you start enforcing a bylaw when there are many violations in a small community? Example, home businesses that do not have business licenses. The concern is that there will be a strong kickback in the community.
Well, I mean so there's two ways to think of that. If council is set on enforcing that bylaw, despite its unpopularity, then you've got to enforce it, and you've got to start with the most egregious offense. and just start with one, and hopefully that sends a message. Also, the one you're most certain in getting a good outcome. But that also goes to the point where if public perception of a bylaw is so bad that you're worried about backlash from enforcing it, you might want to think of just revising that bylaw altogether. If you're going to have optical problems every time you enforce a bylaw, that bylaw probably needs to change.
Perfect. We've got one here from Rob from Lillooet, asking when vague wording is more advantageous for enforcement.
Yeah, it sometimes is. That's correct. It's hard in the abstract to think of an example, but sometimes you define something in a way that's so specific that something that obviously satisfies that category will no longer satisfy because it doesn't have the specific requirements that are laid out in the bylaw. So maybe with derelict vehicles, you ending up defining that with relation to insurance and nothing else. Then you have a clearly derelict vehicle that's on a property, happens to be insured. You don't want it there because it looks ugly. You can't enforce against that. So though I think that derelict vehicles is probably an example of something that can have specific definition, you might get to the point in your definition where you have vehicles that are clearly contrary to zoning that are or unsightly premises bylaws that aren't being addressed because your requirements for what actually counts as a derelict vehicle doesn't really meet people's average expectations of that. So the important thing is to always think about what are the average expectations of somebody and think of hypotheticals, and try to or counterfactuals and hypotheticals, and try to challenge and test your bylaw before it goes into place. Is it going to cover all these situations or not? And that's going to allow you to forge something that's satisfactory to the public.
Perfect. Not seeing any other questions there right now. Maybe we'll give it a second just to see. Oh,
yeah, you can give it
got one more in there now.
Yeah, we have a question.
Go ahead.
Okay, so we run a small water district, and we count on people being honest about different rates that we charge, and we had them fill out their own bill, basically. I mean, it was an old rural community, so people were pretty honest, but now we're getting new people moving in. So an example for this is an extra charge for a suite within a home. And some have been claiming it, some haven't been claiming it. Some of them are renting them out, some aren't renting them out. It's pretty hard to fairly enforce a bylaw like this. What would you recommend?
So rather than speak to the specific circumstances in the sense that it might be something that would be good to get legal advice on, I can say generally that it doesn't sound as if the bylaw in this instance is unenforceable. Just that it hasn't really been, you haven't needed to enforce it yet, and so don't really know how to go about doing it. But like I said for the previous question, is that sometimes you just have to go after one person. Somebody might be upset because they said, well, all these other people are doing it and I'm not. That's not a good excuse for breaching the bylaw. You can't have, it's not good policy that a person is allowed to continue their breach until everyone else has stopped committing the same breach. And so if you choose one particularly difficult or egregious violation, go after them for that. And it sounds like you can prove things with respect to use in dwellings by getting entry warrants and going into the property and seeing that in fact the amount of dwellings that are in the property don't reflect what's being paid.
Yeah, right. Yeah, so basically, I think another way to solve the problem that we're looking at is to put meters in and then just charge for the amount of water, because we've got a lot of different rates. Like if you have an extra dwelling on your property, like it's a rural farm community, an extra dwelling, we're charging an extra amount for that extra dwelling as well. And again, some people have them rented out, some people don't, and all of them are paying the extra charge, and they don't like that, right?
Sure.
So anyway, the problem with the metering and the monitoring is that it's a very expensive.
It's not popular either.
and it's not that popular. But the board members are policemen basically. They got to go around, and people get pretty upset when you start telling them they got to pay for a suite in their basement and there's nobody in it. So I don't know. We're kind of
and that's the kind of thing that you can't exactly choose not to enforce that. And that has to do with, like you said, the growing population of a local government and changes in attitudes over time. You might just have to enforce something that is inherently unpopular until people get used to it. And in terms of being able to figure out, I think in terms, if you don't have metering and you don't have something like that to monitor use in the property, you might just have to choose one specific property is not paying the rate they're supposed to, and I guess kind of make an example out of it.
Yeah, well, we've definitely done that with the additional homestead properties,
right.
And now we've got pretty much everybody in compliance there, even if they don't have people in it. But it's the basement suites you can't see,
right?
that are the problem. It's kind of like illegal suites in cities, right? It's
right.
If you don't.
Yeah, I mean, ultimately, you can try to get in on the property, and it might be one of those things where once one person gets dinged for it, other people get the message. It seems like that did happen in certain circumstances. If you have a problem with the perception of fairness of people paying more than they should, I think maybe you want to start with being more lenient and taking people's words for it, how much, whether a dwelling is actually being occupied or not. And then just doing regular monitoring to try and find the odd person that isn't. I know that doesn't really address the questions that's difficult to do, but from looking at it, just as you said it, I don't know that there's a way around that.
Yeah, I think the additional dwellings is pretty straightforward, but the basement suites is a little more of a problem. And I think your thought about being kind of lenient with it and trusting that they're going to be honest probably is the way to go about doing it for now.
Yeah.
And I think in the future, because our water supply is getting less and less every year because of the climate change, we are probably going to end up doing metering anyway. So
right.
That may solve the problem, but anyway, thank you very much for
no problem. I hope I was able to answer your question.
Yes.
I've got a related comment here from Gwendolyn Kennedy of Pemberton. They're saying that they charge every single family home the extra fee for a suite, and that the homeowner needs to sign an affidavit and request an inspection to be exempted from the provision.
Yeah, that sounds like a great idea too. Yeah.
Could you repeat that? We were kind of turning switches off here and I missed it.
No worries. It's just that in Pemberton, they're charging every single family home for the extra fee for a suite, and that the homeowner needs to sign an affidavit and request an inspection to be exempted from the provision.
That's an excellent idea. Thank you very much. And I think, if we don't go with the metering, I think that's a good way to deal with it. Yeah, thank you very much.
No problem. We've got a couple questions here from Sophia Mischenko in Kamloops.
Okay.
I was just wondering if you can repeat the section of the community charter outlining revision bylaws.
Yeah, that's section 140 of the community charter and the bylaw revision regulation. So the actual provision itself doesn't say much. The aspect of the community charter that does say a lot about it is the bylaw revision regulation. So you have to go and look at that.
And then also, she's wondering, you mentioned there are different forms of amendment bylaws.
What I was just getting at is that certain bylaw amendments have to be done in a procedure that is like just enacting a new bylaw, whereas other kinds, and that's going to be ones that have substantive changes where the law, what's required or permitted, is changed entirely, and then that's in contrast to consolidation bylaws, which just take a bunch of bylaws that were sort of scattered because you have multiple amendments and puts them together. You're not making substantive changes. You're just making it easier to read and understand the bylaw. And then the revision bylaws, under the bylaw revision regulation, what you can do under a revision bylaw is strictly enumerated. So you can only do those things, and they're largely minor kinds of changes, clarification and grammar and that kind of thing, which is different than a substantive amendment. Okay, so I think we've reached the end of the presentation. Thank you everyone for coming. I hope you enjoyed it. I hope you learned something, and we'll see you at our next presentations, which are at the LGCA Annual Training Conference. So Troy D'Souza and myself will be doing Prosecute This 2. If you're familiar with Prosecute This 1, this is an advanced course. You need to, unless you get permission, you need to have taken Prosecute This 1 to do Prosecute This 2. It requires that previous knowledge. I'll be talking about AI for bylaw enforcement, so explaining how local governments are using AI and what to expect in the future. And then Troy will also doing his own presentation called Catch and Don't Release. I'll hope to see you there. Take care.